So we're going to talk about the dispute resolution mechanisms, and we'll discuss the advantages and the disadvantages to each type of resolution method. And we start with negotiation. Now, negotiation has advantages and disadvantages. And again, when we're talking about negotiation, we're talking about a settlement without the use of third parties, with the need for no other third party, just between the parties themselves. And in fact, when you look at the advantages, this is a key advantage, is that it doesn't involve any third persons. If you care about confidentiality, well, the only party that will know about the dispute will be the parties themselves. There are other advantages to negotiation, obviously expense. It doesn't cost much at all. Send an email, pick up the phone, make a phone call. It's easy to and quick to enter into these situations. So less costly in terms of money, less costly in terms of time, confidential, so there's a host of advantages associated with negotiation as a means of resolving disputes. Nevertheless, there are some disadvantages that you should be aware of. And one of the problems that we see in the law, certainly what I experienced when I was practicing law, is that sometimes when there is no third party to push either party to the dispute, the parties tend to become locked in to their ideas. They don't want to move, and one of the reasons they don't want to move is that they are concerned that if they offer to settle, that's going to be interpreted as a sign of weakness, and therefore the other party will push even harder in terms of what their goal is. So negotiation has those advantages, but then there are also important disadvantages. And one of the reasons that we cannot resolve every dispute through negotiation is that parties simply need a neutral party to enter into the negotiations to help push things forward. And this is done in a process called mediation. Mediation is essentially an assisted negotiation. The object in a mediation is to reach a consensual resolution of a dispute, and the parties themselves are going to agree to that eventual resolution. Now, it is very different than litigation. Litigation is a zero-sum game. There's a winner and there's a loser. The goal of mediation is essentially win-win, that the parties each are going to benefit from them. And again, when you are talking about advantages, mediation has a number of advantages. First of all, again, quick in terms of time, that it doesn't take long to set one up. You and I could mediate a dispute tomorrow if we wanted to. It is quick in terms of how long it occurs. Most mediations, regardless of how complicated or extensive the matter is, the subject matter is, most mediations are resolved within a day, sometimes half a day. So it's cheap, it's fast, and in a mediation you're using this third party, and the third party has knowledge of your particular dispute. So if we have a construction mediation, then we'll bring in a person who has mediated construction disputes before. Mediation often involves mediators who have previously been judges, and they are familiar with how matters are resolved. And so we use the benefit of that neutral third party to help push the parties to a position. In a mediation, almost always the mediator will have a number in mind of what they believe the matter should settle for, and they will try to push one party to that number while at the same time pushing the other party to the number. So mediation can have a lot of advantages. Mediation really took hold in business starting in the late 90s, certainly through the 2000s. Mediation offers at least the possibility of a win-win. And one of the things that appeals about mediation, one of the things that appeals to businesses, is the notion that this is the only time in which you are completely in control of the process. You don't have to turn it over to a third party, to a jury, or to a judge, or to an arbitrator. So the parties control their destiny in a mediation. Again, there are disadvantages as well. Mediation is, because it's designed to be a consensual process, oftentimes it can be problematic when one party doesn't want to mediate, or one party simply doesn't want to change their approach. And so they get locked into the same position that they would have been in during negotiation, and it just happens in the context of mediation. And mediation often involves an inability to get information, to get evidence from the other side. And to do that, because there's no means of doing that through mediation, well, you got to go to court and you file a lawsuit, and then you can get that information, and then you can go mediate. But again, you've got to file the lawsuit in order to mediate. You have to engage in litigation in order to get to the mediation stage. So mediation definitely has disadvantages as well. Litigation advantages: it is the primary method to resolve disputes. It's what countries use to resolve disputes. In the United States, we have a very extensive dispute resolution system, and it's called the court system, the judicial system. Every country has its own judicial system, and there is an element of advantage in that everyone knows the system, they're familiar with the system, and they can utilize the system on a somewhat even ground. But of course, there's a lot of disadvantages to litigation. It's expensive, it's very costly, and time consuming. To resolve even the simplest of disputes, you may be looking at 6 months at a minimum, more likely a year or 2 or 3 years. Litigation also offers the opportunity to appeal, and so it becomes a very long-term process that if we go spend 2 years in litigation and we have a jury verdict or a judge verdict, well, if the other party appeals, then you still have another additional year or 2 or 3 to get through to the ultimate conclusion. So it's very expensive in terms of attorney's fees, and it's very expensive in terms of time, and it's inflexible, meaning the rules are the rules, and you are supposed to abide by the rules. Every court has its own rules of procedure, and those are the rules that are imposed on the parties. The parties cannot create their own set of rules, and so very inflexible. All of us, that leads us now to this idea of arbitration. Arbitration is the preferred method for resolving international legal disputes. Now, arbitration is a private resolution method. It's a technique for the resolution of disputes outside of the courts. And the parties to a dispute involve the parties themselves, so the subject matter of the dispute, and then their dispute is going to be heard by an arbitrator, or usually a panel of 3 arbitrators, and they agree in the arbitration agreement to be bound by whatever is the decision, the award of the arbitration panel or the arbitrator themselves. So arbitration resembles litigation in many ways. There's a third party that's going to review the evidence in the case, and that's going to impose a decision, and that decision is going to bind both sides, and it's going to be enforceable in the courts. The most important thing to take away from the study of arbitration is that arbitration is binding. If parties agree to arbitrate a dispute in their contract, the parties must arbitrate the dispute. And once the arbitration panel issues an award, that binds the parties to the award. There is no appeal. There is no right to continue the matter. There's no ability to go to a court and say, look, this decision wasn't fair. Arbitration is binding. Now, arbitration has become widely used in the United States for a wide range of cases. Things like consumer transactions, employment, even civil rights claims. So for any of you who have signed a credit card agreement, almost certainly you entered into an agreement with your credit card provider to arbitrate any disputes that arise out of it. When you click on one of those end user license agreements, like with iCloud or with Xbox or PlayStation, once again, you have agreed to arbitrate any dispute with that party. You do not have a right to bring your claim in court because you have waived that right in your arbitration agreement. And we've seen in recent years the much expanded use of arbitration in employment. Oftentimes this is part of an employment agreement. Probably a third of all employees are bound by an arbitration agreement. So arbitration is certainly widely used in the United States for any number of different types of cases.